One more minute? Yeah.
Oh, yes. Yield the gentleman additional minute.
Gentleman is recognized for an additional 1 minute.
As the way to get anybody to vote for anything around here says it's going to create jobs. Of course, there's been no demonstration of how this is going to create jobs. But the point is that it will create a situation where there's less information to investors who need it. And it's important for members to know that the SEC has taken enforcement actions against private equity firms. You know, for example, in Neilman Asset Management Group, the SEC found that registered private equity fund of funds advisor Neilman Asset Management Group, LLC, Irving Neilman, and Managing Director, Chief Executive Officer, and former CCO, violated the Advisors Act custody, anti-fraud, compliance, reporting, and books and records provisions. There's a case where you have SEC using information to bring accountability in the private equity arena. Also in the area of insider trading enforcement, the Grauwish insider trading case involved an individual who allegedly stole confidential. I'll wrap it up.
All right. We need another 20 seconds.
20
just
seconds.
to wrap up.
Gentleman is recognized for an additional 20 seconds.
So let me just wrap up by saying we urge members to vote no, to look out for advisors. Even private equity advisors need transparency, not less information. A no vote is urged here.
Gentleman from Texas.
Mr. Speaker, at this time I'm very happy to yield 4 minutes to a co-author of the legislation and the chairman of the Capital Markets and GSE Subcommittee, Mr. Garrett of New Jersey.
Gentleman from New Jersey is recognized for 4 minutes.
And I thank the chair, and I thank the chair. And before I give my remarks, I just want to say in response that I believe the chairman said that he is not opposed to all regulation. I think he said he's in favor of regulation, but make sure that it is smart and appropriate regulation. At least that's my position as well. And understand, too, to the gentleman's point, that even when this legislation is passed, the SEC still will have significant authority. It will still have its enforcement division, will still have its new asset management unit, which has recently recruited industry professionals with asset management experience to serve as specialists in this unit to do the investigations that the gentleman wants to have continued, and it will continue even after the passage of this legislation. And so with that said, I want to again thank the chairman. I want to thank the gentleman from Virginia, Mr. Hurt, and also the gentleman, there he is, from Connecticut, Mr. Himes, as well, for their hard work on this very important legislation, as well as all of our co-sponsors on both sides of the aisle. And so for that reason, I'm pleased to support H.R. 1105. And do make no mistake about it, this is bipartisan legislation, and it is all about helping small businesses and helping to create more jobs in this country. You know, today, more than 17,700 companies backed by private equity employ over 7.5 million people. In my home state of New Jersey, alone 597 private equity-backed companies support more than 377,000 workers, while the New Jersey Division of Pension and Benefits has invested billions on behalf of retirees and private equity firms. Hopefully all those facts give you the facts you need to know how much is important to creation of jobs. And yet, despite their long track record supporting small business nationwide, the Dodd-Frank Act has imposed enormous burdens on private equity firms, forcing most fund advisors to spend literally millions of dollars complying now with new SEC registration and reporting requirements. So these burdensome regulations no doubt crimp the flow of what is much needed investment dollars to America's small businesses. And so there's little or no evidence that they are needed to promote the stability of our financial system or to protect investors. So unlike, say, federal housing policy and the government-sponsored enterprises like Fannie Mae and Freddie Mac, private equity did not cause the financial crisis and is not and never has been a source of systemic risk. As former SEC Chair Mary Shapiro admitted back in 2011, she said, private equity funds have less potential to pose systemic risk than any other type of private funds. Indeed, if the SEC is so concerned about the systemic risk of private equity funds, their recent examinations of private equity advisors certainly don't show it. As Chair White recently said, neither the SEC examination staff nor the Division of Investment Management, quote, has conducted examinations of advisors to private funds based primarily on systemic risk. It also said SEC examiners, quote, have not to date reviewed systemic risk issues as part of their examinations of private funds. Thirdly, none of the advisors of private funds that withdrew their registration had systemic risk in the marketplace. And so now we must ask ourselves this question. Do we really want the SEC, already saddled with a multitude of unfinished, non-germane Dodd-Frank mandates, expending valuable resources on risks that don't even exist? In addition, because only sophisticated investors may invest in these private equity funds, the need, if you think about it, to protect investors in this case is more limited compared to other areas of the security market. So while I wholeheartedly support the SEC's mission to protect investors, the agency with limited resources should be devoted first and foremost to protecting the less sophisticated, the retail mom-and-pop investors. They need the most protection. You know, it was Paul Kondrasky who was in Congress back when the Dodd-Frank went through. He said, I, for one, could care less about high-wealth individuals who want to contribute their money to a group of investors. If they want to take the shot of losing it, it does not really affect the rest of society. And it also bears mentioning that this legislation in no way alters the existing tools of the SEC already has to prevent, punish fraud in the private equity industry for the benefit of sophisticated investors and the broader economy. And with that, I urge support of H.R. 1105 at a time when most small businesses continue to have difficulty getting credit and need to grow. Passing this bipartisan legislation, common sense legislation, should be a no-brainer.
Gentleman from Massachusetts.
I give myself just 1 minute to respond to some of these allegations. In respect to sophisticated investors, the Council of Institutional Investors, which is an association representing corporate, union, and public pensions, foundations, and endowments, largely very sophisticated investors, with combined assets of $3 trillion, opposed this bill. They opposed this bill because of the record of enforcement actions of the SEC to go after risks that do actually exist. With that, I yield 3 minutes to Mr. Hines of Connecticut, a co-sponsor of the bill.
Connecticut is recognized for 3 minutes.
Thank you, Mr. Speaker, and I'd like to thank my friend from Massachusetts for the time, and Ranking Member Waters for being willing to hear different perspectives on this bill from our side. And I want to start by saying that Dodd-Frank, which I think I can say I contributed more than my share to, was on balance a very good and very important thing. The dragging of derivatives into the light of day, trading on exchanges, clearing through clearinghouses, the creation of the CFPB, taking steps to eliminate too big to fail. There's lots of stuff in Dodd-Frank which is important and good. But not everything in Dodd-Frank is important and good. Like all other works of mortals, there are things in this that are probably unintended and perhaps overreaching. I happen to believe that the requirement that private equity funds register with the SEC is one of those areas. Why is that? First, private equity funds, as has been pointed out on the floor today, weren't a million miles from the bad mortgages, from Fannie Mae, from Freddie Mac, from the subprime mortgages, from all of those things that caused the failures in 2008. They weren't anywhere close. Secondly, investor protection is important, but by law, the only people who can invest in these funds are accredited investors or institutional investors who don't just sign up. They hire attorneys to negotiate partnership agreements. They negotiate with these private equity funds for disclosure, for the terms, and all of those sorts of things. So we are not talking about retail investors here. Finally, the issue of leverage. We've finally gotten to the point where people acknowledge that these are not large leveraged funds. And the point is made that the leverage is at the investment company level, and that is true. Private equity firms do buy companies, invest in them, and then those companies take on leverage. The average leverage across the entire universe of private equity-sponsored companies is less than 3 to 1. Not 30 to 1. 3 to 1, less than 3 to 1. By way of comparison, hedge funds on average are leveraged 15 to 1. Lehman Brothers, when it went down, was leveraged in excess of 30 to 1. We're talking about companies which are assuming the same kind of debt that any other small business assumes out there, less than 3 to 1. What we have happening right now is we have examiners and the attention and the resources of the SEC, which has terribly important missions around real estate and mortgages and derivatives and finding the next Bernie Madoff, going to $175 million funds and examining these funds on behalf of sophisticated investors. That does not make sense. Dodd-Frank exempted venture capital funds from this registration requirement. Venture capital funds do the exact same thing with the exact same investors that private equity funds do. They just do it at an earlier stage in the company's history. The only reason for that exemption is that we like venture capital funds more than we like private equity funds. They sound better. They make nice things in garages in Palo Alto. Private equity sounds more ominous, and therefore they have been subjected to registration. May I just have another 30 seconds?
Give the gentleman another minute.
The gentleman is recognized for an additional 1 minute.
Thank you. We exempted venture capital funds from 40 Act registration. Same set of investors, same types of investing, actually a more risky asset class than private equity. We exempted them for no other reason than that we like venture capital better than we like private equity. That's fine. But in statute and in regulation, we should be consistent. So I think you can argue that venture capitalists should be subject to the same kind of registration requirements that private equity is, or you can argue, as I do, that probably both types of funds don't need to be registered under 1940. But you can't support Dodd-Frank and say venture capitalists are exempt but private equity is not, and be consistent in policy. So I would urge my colleagues to, in the interest of balancing a very good piece of legislation, to support 1105, and yield back the balance of my time.
Gentleman from Texas.
Mr. Speaker, I'm now pleased to yield 2 minutes to the gentleman from Illinois, Mr. Holmgren.
Gentleman from Illinois is recognized for 2 minutes.
Thank you, Mr. Speaker. Thank you, Chairman Hensarling. What we are trying to do here today is to get small business jobs growing again, and private equity helps do that. The infusion of private investment helps these small businesses create jobs so we can get the economy moving again. Over the last 15 years, private capital has helped about 23,000 small businesses, employing approximately 3 million people. Businesses backed by private capital grew jobs 3.5 times faster than other businesses. We need to encourage this kind of growth by bringing more opportunity, not more regulation. Capital is better spent getting people back to work and growing our small businesses than it is tied up in compliance costs. In Illinois, my home state, more than $200 billion has been invested in local companies. Private equity is about skin in the game, and we need to keep these resources in the economy, not on the sidelines. I ask my colleagues to support H.R. 1105. I am a proud co-sponsor and believe we should pass this important bill, and I yield back.
Gentleman from Massachusetts.
May I ask how much time is remaining for each side?
From Massachusetts has 16 3/4 minutes remaining. Gentleman from Texas has 12 1/2 minutes remaining.
At this time, I'd like to yield 3 minutes to the gentleman from Tennessee, Mr. Cooper.
Gentleman from Tennessee is recognized for 3 minutes.
I thank my friend, the gentleman from Massachusetts. We're seatmates on the Government Reform Committee, and it's a pleasure to serve with you. It's also a pleasure to support this bill. I want to address my remarks particularly to the New Democrats and Blue Dog Democrats, because not everyone in this body is an expert on private equity or venture capital. This sounds like a complicated topic. It sounds technical, but it's really all about jobs. And there's nothing we get asked more back home than about creating jobs. There's nothing we talk more about here than creating jobs. Passing this bill is a good way to do that. It's easy to get wound up in the details, but the bottom line is this. Private equity creates jobs. These are funds who have wealthy investors investing in them, and they lend their money, they invest in growth companies that create jobs. My friend from New Jersey mentioned they've already helped create 7.5 million jobs in America, some 17,000 individual companies. These are the companies we try to recruit to our districts. These are the companies that we try to grow back home so that more of our good people back home can have good jobs. The paperwork requirement that unfortunately, and I think probably inadvertently, was put on them by the Dodd-Frank bill needs to be removed. SEC registration is not appropriate for these funds. It costs between $750,000 and $1 million a year for them just to do the paperwork. That's money taken away from job creation. That's money that's embalmed in red tape. So this is a chance, and we do need to make sure there's a Senate companion to this bill once it passes the House. I'm proud of my colleagues for being involved in a bipartisan job creation effort, because folks who really understand venture capital and private equity know this is a great way to help create more jobs in this country by removing a little bit of the red tape that probably shouldn't have been there to begin with. You know, this bill passed the Financial Services Committee last session of Congress by voice vote. By voice vote. This shouldn't even be controversial. This year the vote was overwhelming, 38 to 18. So I hope my colleagues, particularly among New Democrats and Blue Dogs, will understand this is a job creation issue. This is a bipartisan job creation opportunity. 1105 should pass with overwhelming bipartisan support. Let's get this through the Senate, and let's create more jobs in America. I thank the chairman for yielding time, and I hope all my colleagues will vote for 1105. Thank you.
Gentleman from Texas.
Mr. Speaker, I now yield a minute and a half to the gentlelady from Missouri, Ms. Wagner.
Gentlelady from Missouri is recognized for 1.5 minutes.
Thank you, Mr. Speaker. And I want to thank Chairman Hensarling of our Financial Services Committee and also the gentleman from Virginia, my friend, Mr. Hurt, for their very hard work in bringing this important legislation to the floor today. Mr. Speaker, today I rise in support of H.R. 1105, the Small Business Capital Access and Job Preservation Act. This legislation addresses yet another misguided provision of the Dodd-Frank Act that will help ensure that private equity maintains its critical role in our economy. Private equity firms provide capital to Main Street businesses in Missouri and all across our country. And importantly, private equity often invests in companies when others are unwilling to do so. These investments support nearly 18,000 businesses in the United States that employ some 7.5 million workers. Unfortunately, the Dodd-Frank Act seeks to make it more difficult for private equity to maintain this important economic role. To my knowledge, no evidence has been produced which shows that private equity was a cause of the 2008 financial crisis or that it presents a systemic risk to our financial system. It makes sense, little sense then, to impose unnecessary and costly red tape burdens on private equity investors, which will only make it more difficult for them to invest in American businesses and create jobs. H.R. 1105 is therefore a necessary response to an overreach of the Dodd-Frank Act and will help support Main Street businesses and jobs all throughout our country. I am pleased to support this very bipartisan bill and urge my colleagues to vote in support of H.R. 1105. I yield back.
Gentleman from Massachusetts.
I yield myself to the time as I may consume.
Gentleman is recognized.
I do want to point out, in response to the gentleman from Tennessee's remarks about this bill going on voice vote in committee, I just want to remind the members and the public that during that debate there was a need for further work on this bill. And I think in a moment of bipartisanship, we agreed, both Democrat and Republican, to allow the bill to go by voice vote with a promise to work on some of those issues going forward. So it was an agreement to try to continue to agree and to work on the bill. It was not a vote in favor of any particular provisions within this bill. There's been a lot of talk here about the risks that don't exist, and I do want to just point out some of those. As a result of this bill, funds investing more than $300 billion a year, much of which is the retirement savings of workers like teachers, firefighters, police officers, they would no longer be required to provide basic investor protections. Specifically, H.R. 1105 would deprive investors of basic disclosures about an employee of a fund advisor who, for instance, violated securities law, the advisor's business practices, its fees, any conflict of interest on the part of that advisor. It would also eliminate a compliance program and code of ethics within the bill, within Dodd-Frank, and would eliminate the need for a chief compliance officer for each fund manager. H.R. 1105, the bill under consideration here, would also prevent the SEC from conducting compliance exams of private equity fund advisors, even though SEC Chairman Mary Jo White notes that the Commission has already uncovered issues such as unlawful pay-to-play schemes, insider trading that we've all read about recently, conflicts of interest, valuation issues, and misappropriation of assets. I want to talk about some of these. Since there's been a complete dismissal of any risk here, I think the record speaks to the risk. The SEC has brought several enforcement actions against private equity firms. While the defendants do not necessarily represent all private equity firms, they do highlight the need for a strong police officer with the authority to examine all private equity advisors. Capital formation relies on investor confidence in the underlying assets, and without registration with the SEC, investors will no longer have a cop on the beat that can enforce the rule of law, reducing investor demand. In Nelman, for example here, there have been broad violations related to fraud, custody, compliance, and reporting. In Nelman Asset Management Group, the SEC found that registered private equity funds advisor Nelman Asset Management Group, LLC, and Irving P. Nelman, KMG's Managing Director, Chief Executive, and former CCO, violated the Advisors Act custody, anti-fraud, compliance, reporting, and books and records provisions. In an insider trader enforcement, the Gowrish insider trading case involved an individual who allegedly stole confidential acquisition information from his employer, TPG Capital, and sold that information to two friends who made $500,000 in illicit trading profits. Valuation-related enforcement actions. The Oppenheimer-Brian Williamson matter concerned an investment advisor and portfolio manager who misrepresented material details about his valuation methodology to his investors. Recently, the Commission filed a case against Yorkville Advisors, where Yorkville allegedly inflated the values of certain liquid assets. While Yorkville managed hedge funds, the valuation issues are very similar to ones we see in private equity. Finally, KCAP valuation case involved alleged overstatements of the value of certain debt securities and CLOs held in the investment portfolio, highlighting the division and AMU's emphasis on pursuing valuation cases. And in the Ranieri Partners case, the SEC also found that an investment manager knowingly used a sanctioned, unregistered broker-dealer to solicit capital for a pooled investment vehicle. So all of these illegal activities would be made unavailable to private equity investors under this bill. That's what the risk is. That's not fiction. Those are actual cases that the SEC has introduced enforcement actions on. So there is real risk here for investors and for the markets themselves. And with that, I yield. I actually reserve the balance of our time.
Gentleman's time is reserved. Gentleman from Texas.
I yield myself 30 seconds, Mr. Speaker, to say that the gentleman from Massachusetts sets us with straw man and then knocks it down. The activities that he described as illegal continue to be illegal, and I would say that private equity funds provide extensive reporting to investors, including audited annual financial statements. Private fund equity advisors are subject to the anti-fraud provisions of the Investment Advisors Act of 1940, whether they are registered or not, and fund offerings are subject to the anti-fraud provisions of the Securities Act of 1933. The real choice becomes, are we going to get even greater protections for millionaire investors? Are we going to help struggling single moms trying to find a job in this economy? Mr. Speaker, at this time, I am happy to yield 2 minutes to the gentleman from Ohio, Mr. Stivers.
The gentleman from Ohio is recognized for 2 minutes.
Thank you, Mr. Speaker. I'd like to thank the gentleman from Texas for yielding time. The Small Business Capital Access and Job Preservation Act is an important bill that I believe will allow more capital to go and flow to small business so they can create jobs. You know, at a time when we have 7.3% unemployment and underemployment over 10%, we have a need for more capital to flow into our businesses so they can create jobs. Meanwhile, the Dodd-Frank Act created burdensome new SEC registration on private equity firms, but as the gentleman from Connecticut said earlier, not on venture capital firms that do exactly the same thing. So, in fact, I would argue that venture capital firms have more risk than private equity. There already are important protections, consumer protections around private equity. You have to be a sophisticated, accredited investor, and there's already important fraud detection and fraud enforcement actions that are available to the SEC in the cases of these investors being taken advantage of. So at a time when private equity is helping provide over 6 million jobs in America, we should be doing everything we can to actually encourage more activity by private equity, to encourage more jobs in America, not burdening them with big regulations. And I want to just make 4 quick points. These middle market private equity firms, like we have in towns like Columbus, Ohio, where I live, contribute a lot toward job creation, but not a lot towards systemic risk. And the compliance cost for these smaller firms in towns like Columbus, Ohio, will be especially high as a percentage, and it could drive many of them out of business. Many of these firms that manage both SBIC and non-SBIC funds already face multiple layers of regulation. And the 4th point is, many of these investment advisor rules are not really pertinent to private equity funds. So I stand in support of the Small Business Access and Job Preservation Act. I want to thank the gentleman from Virginia, Representative Hurt, for his hard work on this. I think it's a win for job creation, and I urge all my colleagues to support it. I yield back the balance of my time.
Gentleman from Massachusetts.
I give myself a couple of minutes here just to address.
Gentleman is recognized for 2 minutes.
Thank you. We need not worry about small firms in this. They're already exempt under this bill. They are already exempt. So the concerns about small firms being covered by this, they're already exempt, number 1. And number 2, the other assumption or the other scenario that's been posited here is that somehow by allowing private equity firms the right to keep secret the fact or to refuse to disclose that their employees have been prosecuted for violating securities laws, by allowing that to remain undisclosed, that's going to help some single mom go to work. I don't think that is a rational assumption. I would like to. I'm going to ask this. I have a bunch of stuff here I have to admit to the record, but thank you. I'd like unanimous consent to enter into the record letters from the following organizations. All oppose this bill. 1, Americans for Financial Reform, a letter from the AFL-CIO, a letter from California Public Employees Retirement System, a letter from the Consumer Federation of America, a letter from the Council of Institutional Investors, a letter from the North American Securities Administration Association, and a statement of the administration policy from the Obama administration. I ask unanimous consent that they be entered into the record.
Without objection.
And I ask to reserve our time.
Gentleman's time is reserved. Gentleman from Texas.
Mr. Speaker, I'm very pleased now to yield 1 minute to the gentleman from Tennessee, Mr. Fincher.
Gentleman from Tennessee is recognized for 1 minute.
Thank you, Mr. Chairman, for yielding. Mr. Speaker, strong job creation is the foundation for a healthy economy, while overregulation kills jobs. Private equity provides much-needed capital and better investment returns to pension plans, university endowments, charitable foundations, and other investors than if they simply deposited their money in a bank. The various forms of capital provided by private equity in our economy result in more resources for companies to operate their firms, expand their facilities, and create more jobs. H.R. 1105, sponsored by my good friend from Virginia, Mr. Hurt, would help expand private equity by relieving certain advisors to private equity funds from the burdensome and unnecessary process of registering with the SEC. This bill would simply allow advisors and private equity firms to do what they do best, invest in promising companies in order to help them expand and create more jobs. Let's support job growth in this country by voting in favor of H.R. 1105. I yield back the balance of my time.
Gentleman from Massachusetts.
Could I ask how much time is remaining on each side?
Gentleman from Massachusetts has 7 3/4 minutes remaining. Gentleman from Texas has 7 1/2.
I'd like to yield 2 minutes to the gentlelady from New York, Ms. Maloney.
Gentlelady from New York is recognized for 2 minutes.
I thank the gentleman for yielding, and I would like to remind my colleagues that we are still recovering from a massive financial crisis that cost this country $16 trillion. And I would venture to say that we should be more focused on protecting investors, not removing investor protections. And I would say that all investors deserve to be protected. Sophisticated investors, retail investors, pension investors, all investors should be protected, which is why the Obama administration has come out so strongly in opposition to the underlying bill, and why the Securities Exchange Commission, whose mission is to protect investors, is so adamantly, strongly opposed to this bill. Now, I am sympathetic to the point that my colleagues have raised on the other side of the aisle and on this side of the aisle, that some of the reporting and registration requirements are onerous. So let's address that. Let's direct the SEC to come forward with simplified forms, to do it quickly within 6 months. Let's save money. Let's simplify the process. But let's not remove important investor protections, such as the fiduciary duty to act in the client's best interest. What's wrong with that? I think that's a moral responsibility. Such as the obligation to disclose conflicts of interest. Now, that's not onerous. How difficult is it to say yes or no? I have not had any conflict of interest, or if you are advising your client to invest in your business, then disclose your conflict of interest. What's so onerous about that? That's not onerous. That's easy. And what's wrong with the obligation to disclose fees? Everyone talks about transparency. That is why we are opposing this bill. We want it to be transparent, and we want to protect investors.
For an additional 1 minute.
Well, I feel that there are many ways that we could address this that would come forward with a strong piece of legislation that President Obama could sign into law. Instead, he's got a lot of ink in his veto pen, and he has said right out front he will veto this bill. Now, if they want a simplified disclosure and registration requirement, then let's do that. Let's require the SEC to come forward with it. Let's simplify the process and save the cost for small businesses. We want to save that cost. And honest private equity firms have grown jobs in this country, and it's important to grow jobs. It's important to support them in every single way. But by removing all investor protection, according to the Obama administration, would literally assault the safety and soundness and the strong financial security that we're trying to build in this country. What's wrong with protecting investors? That's what we're saying. I have an amendment which would do just that, protect the investors, but simplify the forms and maintain the cost. If their goal is to save the money for the small firms, then let's do that. But let's not erase very important investor protections in the process.
Gentlelady's time has expired. Gentleman from Texas.
Mr. Speaker, I yield myself 1 minute.
Gentleman is recognized.
Again, I want to address the gentleman from Massachusetts who, again, I believe sets up a straw man only to knock it down. I would urge all members to actually read the bill. I know that many of my Democratic colleagues now have buyer's remorse from not reading the 2,000-page Obamacare bill. But, Mr. Speaker, this is a 2-page bill, 36 lines. And I would say to my friend, the gentleman from Massachusetts, that on page 2, that the SEC can, quote, require investment advisors described in paragraph 1 to maintain such records and provide to the Commission such annual or other reports as the Commission, taking into account fund size, governments, invested strategy, and other criteria, determines as is necessary. So to make the assertion that these records of foul play could never exist is simply not true. I would say to my friend, the gentlelady from New York, who made the assertion that the SEC has opposed this bill, I yield myself an additional 30 seconds. The SEC has not opposed this bill. One member, Mary Jo White, has issued an opinion that she does not support the legislation, but the SEC has taken no official position. With respect to a threatened veto, I don't recall that when my Democratic colleagues had the majority here that they refused to pass bills simply because President Bush threatened a veto, but I must admit our committee has produced, I believe it is at least 10 or 11 bipartisan bills, all receiving veto threats from a president who says he wants to work on a bipartisan basis. This is most regrettable.
Gentleman from Massachusetts.
Thank you. I yield myself 2 minutes.
Gentleman is recognized.
No? Well, I have to re-enter. There was a problem with submitting some documents for unanimous consent. I'd like to unanimous consent to enter into the record for the following organizations which all oppose H.R. 1105, the AFL-CIO, California Public Employees Retirement System, and North American Securities Administration.
Without objection.
And regarding reading the bill, I certainly did read the bill, and my point is that the bill does not require public disclosure of those matters, as the gentleman points out. It just goes to the Commission. So it doesn't go to the public. The public doesn't get the information. It stays within the custody of the Commission. That's my point. Sure, I will.
By definition, it's private equity. It is not a public fund.
Right. But those are public investors. They're the ones that need the information. Mr. Speaker, I'd like to yield the balance of our time to the gentlelady from California, Ms. Waters, our ranking member and a real champion of America's working families.
Gentlelady from California is recognized for the balance of the time, which is 3 3/4 minutes.
Thank you very much, and I'd like to thank the gentleman from Massachusetts for managing in my absence. I'm pleased to have the opportunity to come back to the floor to add a few comments. Prior to leaving, the chairman of this committee talked about this being a job creation bill. He wrapped this bill in jobs creation, and I must say that I don't think that the gentleman had much else he could say about why they are trying to exempt all of these private equity funds from registering with the SEC. Wrapping it in this notion of they're creating all of these jobs and we should all be very appreciative is one way to deflect attention from the fact that here we have private equity funds, $180 million from the smaller private equity funds have been exempted already. Those firms that have $180 million in those funds or less are already exempted. That was done in the Dodd-Frank legislation. Now they're coming back and they're saying exempt everybody. What is it you're trying to hide? Why is it you do not want these firms to register? Well, first of all, they are registered at this point. The SEC is given the oversight and the regulation that they need, and they're finding that it is very important for them to do so because they're finding that there are unlawful pay-to-play schemes, insider trading, conflicts of interest, and misappropriation of assets, et cetera, et cetera. That's not to say that all private equity funds are doing these things, but weeding out the bad apples is extremely important. The SEC is our cop on the block. They're there to protect the investors. This is their #1 responsibility, and we want them to do this. Just as you have CalPERS from California that's against this bill, they should be against this bill. They have the retirement funds of policemen and firemen and all of the middle-class people that make up the basis of this economy. Well, let me just add to the ones that were mentioned by my friend from Massachusetts. We also have Americans for Financial Reform. We also have the Consumer Federation and all of the state regulators who are against this bill, and the President's advisors have said they're recommending a veto. What do you have to hide? Why don't you want registration? That's the question that must be asked. That's the question that had really not been answered. And, Mr. Speaker and members, I would ask for a no vote on this bill because we endanger the investors that they claim they want to protect because they claim they want them to produce all of these jobs. And certainly that will never happen if we allow the kind of situations to continue to happen that was described under the discussion about Bain Capital in the presidential elections debates. Do I still have time, Mr. Chairman?
Gentlelady remains to be recognized, yes.
Thank you very much. Now, further, let me just say that we have worked very, very hard to try and make sure that we have protection. That is the role of the SEC. And again, they already have these registered private equity firms that they are taking a look at, and they're learning things about them. And this information will be used to make sure that we have the kind of private equity funds that can do the kind of jobs that we want them to do. Yes, we appreciate investment. Yes, we want job creation. But why should we have private equity and funds that somehow have no oversight, that don't have anybody scrutinizing what they're doing? Why is it we don't want any regulatory agencies looking at them? That just doesn't make good sense. And I would say to my friends, you have to oppose this bill. There will be an amendment coming up that was mentioned by Ms. Maloney that makes good sense. And if they had gone to that simply as a way of trying to help out in this area, they could have gotten a lot of support. But they've stepped way over the line when they say no oversight, no scrutiny by the SEC or anybody else. I yield back the balance of my time.
Mr. Speaker, I'm very happy to yield 2 minutes to the gentleman from New Jersey, again a co-author of the legislation and the chairman of our Capital Markets and GSE Subcommittee.
Gentleman from New Jersey is recognized for 2 minutes.
And again, I thank you, the Chair. So let's step back for a moment and just see where we may agree on certain points. And I guess at the 30,000-foot level, we agree on the fact that we want to work together on legislation that will try to prevent the next fiscal or financial crisis. We agree that we want to try to protect investors. It's after that level, however, and get into the details, that we disagree. As far as protecting and trying to make sure the next financial crisis does not occur, there has been no evidence, either today on the floor or in the committee process during the discussion of this debate or in any of the debates when we discussed Dodd-Frank, that the origin of the last financial crisis was from private equity, no evidence, or from hedge funds, no evidence, or from venture capital, no evidence whatsoever. So to say that we need to have extensive, overbearing, overlapping, extraneous regulations on private equity to prevent the next one, they have no evidence to say that that was the cause in the past. So we say, just as the gentleman from Connecticut said before, venture capital was excluded from it. Why not private equity as well? And that's why we have come together in a bipartisan manner to make sure the next crisis doesn't occur in an area such as this. Second point was made as far as the cost. The gentleman from Massachusetts said, well, we're talking about the larger funds here. If he was at the hearing last night on Rules Committee, he would have heard one of his colleagues, Mr. Polis from Colorado, refute that point. Why is that? Because when you're talking about firms, this is what he said last night. It's really interesting. When you're talking about firms, $150 million, $200 million sound like large firms, right? But that's just how much money is under management. The actual profits, the actual money they're actually spending in the company is just a fraction of it, a little tiny fraction, as he pointed out, around 2%. So if you're talking about a $150 million fund under management, sounds big. Actually, you're talking about, let me do the math, that's around a $3 million business. And now you're asking that $3 million to have to pay upwards to $500,000 each year for all their compliance costs and the examination, which goes to the last point by the gentlelady from New York.
The gentleman, an additional 30 seconds.
Okay. Gentleman is recognized.
The last point is the gentlelady from New York. We would love to try to find some common ground on her amendment, but her amendment simply goes to the first point of as the initial filing of the forms and what have you. After that, there's the extraneous additional examinations and all the other costs that is so overly burdensome that we have found in both in a bipartisan manner, as Mr. Himes from Connecticut has already pointed out, is overly burdensome and unnecessary. If there was some other way to pull this together on a bipartisan manner, more so than we have already done so, I would do so, but I'm glad that the gentleman from Virginia and also the gentleman from Connecticut have been able to come together on all the points to come to a final bill in a bipartisan manner, and I support the legislation.
Gentleman from Texas with 3½ minutes remaining.
Thank you, Mr. Speaker. I yield myself the balance of the time.
Gentleman is recognized.
You know, Mr. Speaker, listening to some of my colleagues on the other side of the aisle, it's hard not to conclude that some of them have never met a regulation that they didn't like, regardless of what it does to the hopes, dreams, aspirations of the unemployed and underemployed in America. As I look over your chair, Mr. Speaker, and I see the words, "In God We Trust," I sometimes question whether some members would like to take down the word God and replace it with regulators. In regulators we trust. The question has never been, Mr. Speaker, the question between regulation and deregulation. The question is between smart regulation and dumb regulation. And in order to make that determination, one needs to see what cost is being imposed, again, on the hopes and dreams and aspirations of the unemployed and the underemployed. Why does this underlying regulation need to be there in the first place? Is it systemic risk? Well, even the chairman of the SEC has admitted that private equity played no role in the financial crisis. We know in terms of the economy, private equity may represent somewhere on the order of 1.5% to 2% of GDP. There's no evidence of interconnectedness, which many maintain is at the root of systemic risk. So what are they trying to protect? Well, investor protection. This is all about giving additional protection to millionaire investors at the expense of single moms trying to make ends meet. I'm not really sure that meets the test of smart regulation. And we know already that private equity fund advisors are subject, as they well should be, to the anti-fraud provisions of the Investment Advisors Act of 1940, whether they are registered or not. Fund offerings are subject to the anti-fraud provisions of the Securities Act of 1933. The SEC still has the ability to ensure that proper documentation is maintained. No, we do not want to see any investor, regardless of sophistication or income, be subject to coercion or fraud, but at the same time, we don't want to deny small businesses, the job engine in America, the funding they need to put America back to work. There are many companies today that we recognize, Dunkin' Donuts, Baskin-Robbins, Petco, Skype, J.Crew, that all have benefited from private equity. Where would the tens of thousands, if not hundreds of thousands of jobs they represent be today if private equity had to face yet another burden that is going to cost these small investment firms $500,000, $1 million? Now, today we haven't really heard that much about companies like Intrust, Universal Smart Comp, but maybe they're tomorrow's Petco, tomorrow's Toys R Us. And so it really comes down to this, Mr. Speaker, again. Are there going to be additional protections for multimillionaire investors? Are there going to be additional protections and opportunities for unemployed single moms trying to make ends meet? Our side of the aisle said, let's help the single mom. Let's pass H.R. 1105 and put America back to work.
Gentleman's time has expired. All time for debate has expired. For what purpose does the gentlelady from New York seek recognition?
I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 1, printed in Part B of House Report number 113-283, offered by Mrs. Carolyn B. Maloney of New York.
Pursuant to House Resolution 429, the gentlelady from New York, Ms. Maloney, and a member opposed, each will control 5 minutes. The chair recognizes the gentlelady from New York.
I thank the chair, and I first want to commend the chairman and the ranking member for their hard and dedicated work on the Financial Services Committee. And I'd also like to commend the vice chairman, Mr. Hurt, Congressman Hurt, for his work on this bill. And I agree with him that private equity funds did not cause the financial crisis. And I also agree that many private equity funds, and especially the small private equity funds, invest in middle market businesses that support jobs across our country. I also agree that for many small equity funds, the cost of complying with every single requirement in the Investor Advisory Act can be burdensome and costly. However, while I share the goal of reducing unnecessary regulatory burdens on small private equity funds with under $1 billion in assets, I believe that there are better ways to accomplish this goal, to reduce the burden, to reduce cost, without eliminating important investor protections. And I would say that we should have equality in this country, and equality of treatment to everyone, including investors. And if you're a small investor, a large investor, a teacher, an unemployed worker, and you've invested, whoever you are, you should have protections. Aren't we a country of laws and equality of treatment? So my amendment would direct the SEC to create a simplified disclosure form for fund advisors between $150 million and $1 billion, while also retaining important investor protections. So we would reduce the burden, reduce the reporting, reduce the disclosure, simplify the forms, make it easier, but protect the fiduciary duty to act in a client's best interest. Isn't that the moral right thing to do? The obligation to disclose conflicts of interest and the obligation to disclose fees. I thought we all supported transparency. Well, let's have transparency in these investment funds too. Now, I would ask my colleagues on the other side of the aisle who are objecting to this amendment, how much of a burden is it to disclose whether or not you have a conflict of interest? You just have to check yes or no. I have a conflict of interest. Then maybe you have to disclose what that conflict is. But that's the fair and right thing to do. How burdensome is it to disclose fees? Tell people what you're charging them. And how burdensome is it to have the really necessary fiduciary duty to act in the client's best interest? Most people think that you are acting in their best interest. I think they'd be horrified to know that some members of this body want to roll back that protection for them. I would also like to note that in August, the SEC did provide relief for smaller private equity funds from what the industry tells me is one of the most burdensome aspects of registration, the so-called custody rule, which requires that the funds use independent custodians for stocks that don't even trade. So private equity funds have already gotten relief, and I applaud the SEC for this common sense decision. The reforms in my amendment would build on this relief and would direct the SEC to act quickly on simplified forms within 6 months and save these small businesses money so that money can go out into the community. The underlying bill grants a complete exemption to private equity fund advisors with under 2-to-1 leverage, which is pretty much the entire industry, because the funds themselves are not leveraged. It's the companies the funds invest in that are leveraged. The underlying bill is opposed by the Securities Exchange Commission, whose prime mission is to protect investors, and by the President Obama's administration. And he has even threatened a veto. If the problem is the high cost of registering at the SEC and preparing the required disclosures, then the solution is to simplify the registration and disclosures for small equity funds. That's what my bill does, but it also protects investors. It does not exempt the entire industry from investor protection, which is what the underlying bill does. And I do not believe that that is the intent of my colleagues on either side of the aisle. So my amendment accomplishes the goal, the expressed goal of saving money, simplifying, but protects the integrity of our financial system and investors. So I would like to yield, reserve the balance of my time.
The gentlelady's time has expired.
Oh, I urge everyone to support my amendment.
For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I rise in opposition to claim the time.
The gentleman is recognized for 5 minutes.
Yield myself as much time as I may consume. Mr. Speaker, the amendment, regardless of how well-intentioned it may be, functionally guts the bill and is essentially redundant of current law in Dodd-Frank, perhaps, and I certainly grant the gentlelady, who is a very senior and thoughtful member of our committee, that her provision is perhaps more articulate than the underlying law, but Section 408N of Dodd-Frank already says, quote, in prescribing regulations to carry out the requirements of this section with respect to investment advisors acting as investment advisors to mid-sized private funds, the Commission shall take into account the size, governance, investment strategy of such funds. It goes on to say that the Commission shall provide for registration and examination procedures with respect to the investment advisors of such funds which reflect the level of systemic risk. So again, it is essentially redundant of what is already in current law, but according to the Private Equity Growth Council, on average, it is taking $1.8 million for the initial Dodd-Frank compliance cost and an additional $1.3 each year in Dodd-Frank compliance cost. All for what? All for what? We already have underlying investor protections in place. No evidence presented whatsoever that this has anything to do with systemic risk, all at the cost of jobs at a time when, again, Mr. Speaker, tens of millions of our countrymen are struggling, underemployed, unemployed. Again, who are we going to help? Are we going to help regulators? Are we going to help millionaire investors? Are we going to help struggling Americans trying to pay the bills? And so we should oppose this amendment, Mr. Speaker. And at this time, I'd be very happy to yield 2 minutes to the gentleman from Virginia, Mr. Hurt, again, the author of H.R. 1105.
Gentleman from Virginia is recognized for 2 minutes.
Thank you, Mr. Speaker, and I thank the chairman. I rise in opposition to the gentlelady's amendment. I appreciate her work and interest on this important issue, but with all due respect, this amendment would defeat the entire purpose of the bill. If adopted, all advisors to private equity that are currently undergoing the burdensome and unnecessary registration process would still be required to do so. Additionally, it would establish an entirely subjective, so-called simplified compliance standard that would have to be defined by the Securities and Exchange Commission. There is no reason to believe that such a so-called simplified standard would provide any meaningful relief for those private equity companies investing in small companies across this country. As has been stated, small and mid-sized private equity firms are expending hundreds of thousands of dollars in annual compliance costs and would still have to be registered with the SEC. Instead of addressing this problem, this amendment, if adopted, would continue to restrict the ability of small and mid-sized private equity firms to invest in small business. As members of both parties have pointed out, there are not persuasive arguments that private equity generates systemic risk. And indeed, to the extent that leverage at the fund level could potentially trigger such risk, we have already adopted a standard proposed by Mr. Himes in committee that would require registration for advisors to firms with leverage that exceeds 2 to 1. I know that the gentlelady understands that access to private capital is the lifeblood for small business.
The current SEC registration requirements are unnecessary. They produce significant burden on private equity firms and therefore restrict the flow of private capital to small businesses across the country. I urge this body to defeat this amendment and vote in favor of the underlying bill. Thank you, Mr. Speaker, and I yield back the balance of my time.
Gentleman from Texas.
Mr. Speaker, how much time do I have remaining?
Gentleman from Texas has 1 minute and 30 seconds remaining.
I'll yield myself the balance of the time.
Gentleman is recognized.
Thank you, Mr. Speaker. Again, private equity historically has invested in tens of thousands of small businesses, helped create millions of jobs in America. And the question is today, are we going to put a roadblock in place of private equity, these small business investment engines, so that we can somehow help regulators, and with all due respect to our regulators, and there are many good ones, many great ones at the SEC, but I've never met a regulator who turned down the opportunity to regulate more. I've never met them. And so the question is, are we going to grant even greater ability to take funds away from small businesses to create a work product that doesn't meet the common sense test, the jobs test, the smell test, or any other test at a time when people are still suffering and wondering how are they going to put gas in the tank, how are they going to take their kids to school, how are they going to afford their health care bills, since clearly they cannot keep their health insurance even if they want to. How are they going to do this? We need private equity to fund small business, to get America back to work. We need to defeat this amendment. We need to pass the underlying bill. It is time to be pro-jobs. And with that, Mr. Speaker, I yield back the balance of our time.
Gentleman yields back his time. All time for debate has expired. Pursuant to the rule, the previous question is ordered on the bill as amended and on the amendment offered by the gentlelady from New York, Ms. Maloney. The question is on the amendment by the gentlelady from New York, Ms. Maloney. Those in favor say aye.